Helen Lord, the middle-aged schoolteacher who was accused of assaulting and wounding Constable William Forbush at Calderley Police Station on May the 16th, was 2 days before the incident dismissed from her provisional position at the John Fordhouse Comprehensive School by the headmistress, Mrs. Eunice Bentley. On the same day, Mrs. Bentley received a letter concerning Miss Lord from the Chief Constable's office. The man who signed the letter, Detective Superintendent Brotherton, has insisted that the contents must remain confidential. Nevertheless, Mr. Harry Dealey, Miss Lord's counsel, is trying to get the letter introduced in evidence despite strong opposition from Mr. Charles Lotterby for the prosecution, who is claiming that the letter is privileged information.
Well, there would seem to be certain precedents. Just a moment, Mr. Dealey. Yes, I refer you to Conway and Rimmer, 1968. Now, the judge in that case supported a claim of privilege, ruling that the very nature of a class of document may resist application to disclosure.
But surely in this case, Your Honour, the courts was dealing with government papers of one sort or another, the disclosure of which would not have been in the public interest.
The principle might well be extended to embrace our interest here.
Only if we consider it our duty to shield the police at all costs.
I beg your pardon?
Well, am I to take it that Your Honour is anxious in this case to spare the Chief Constable's office all possible embarrassment?
I must earnestly suggest that you withdraw that remark, Mr. Dealey.
My meaning is this, Your Honour, that there is a profound difference between government papers and a letter from the Chief Constable's office giving information about an individual such as we have here. The one is worthy of protection and discretion, the other is contemptible and arguably libelous.
Oh, come on, you can't mean that.
Well, if I laid similar information, my letter would be actionable.
Well, that's as may be. After all, you're not the
Police, were you going to say? I do hope not.
Mr. Dealey, are you maintaining that the letter says something relating to your client which is not in fact true?
I'm maintaining that it might, Your Honour. But how can the court know until it is introduced?
But you've admitted to knowledge of the contents.
Yes, Your Honour.
Well, then, in your opinion, does the letter say something which is not in fact true?
Your Honour, I must apologise for my impertinence and hasty speech. But we are here concerned with the whole question of privilege before the law. Now, English courts have always been slow to concede privilege. A doctor cannot withhold his patient's confidences, for example. A priest, the secrets of the confessional.
That's arguable. In one famous precedent, a Chief Justice ruled that he would never compel a clergyman to divulge against his will. You'll find that's Queen against Griffin, 1853.
Also Brawden Pitt, 1828, Your Honour. A very similar affair.
Indeed, Mr. Lotterby?
Oh, it's not in the latest Archbold, Your Honour. You'll find it in the 35th edition.
Oh, I see.
So the application of case law rests with the bench, then, Your Honour?
As always, Mr. Dealey, as always. Now, you are concerned to show that your client's state of mind at the time of the attack on Constable Forbush was critical. Isn't that the case?
Obviously, Your Honour.
Well, I would have thought we were some way towards establishing a disturbed state of mind as things stand. The introduction of the letter doesn't seem to me to be absolutely necessary at this point. Of course, these are matters not for the bench, but for learned counsel. Questions of emphasis, presentation, Mr. Dealey. Since I do not myself believe that disclosure is absolutely necessary at this point, I uphold for the time being my previous ruling that the document shall not be admitted in evidence. Mr. Dealey, do you wish to continue cross-examining the witness, Mrs. Bentley?
If Your Honour so pleases.
Mrs. Bentley, will you come to the witness box, please? Remember, you're still under oath.
Mrs. Bentley, did anything happen on May the 14th to change whatever assessment you might have made of Miss Lord's character?
No, not directly. I have already told the court that I made up my mind to dismiss Miss Lord before the letter arrived.
That wasn't quite what I asked you. So, the letter in fact did tell you something relating to Miss Lord's character then?
Well, yes.
Something detrimental? Mrs. Bentley?
Yes.
I'm sorry, I can't quite hear you, Mrs. Bentley.
Yes.
Thank you. Now, supposing you had formed a favourable opinion of Miss Lord's teaching abilities, would that letter and what it have told you been sufficient still to have made you dismiss her?
That's a very difficult question, Mr. Dealey.
I think you might make some effort to answer it, Mrs. Bentley.
Well, how can one say? It's always impossible to say how one would have acted, and circumstances have been different. You're putting a hypothetical case, Mr. Dealey.
Only to find out, if I can, what effect that letter truly had on you, Mrs. Bentley.
I repeat, it had none.
None whatever?
None on my decision. Miss Lord, in my opinion, was not a suitable teacher for John Fordhouse, and that is why I got rid of her.
Got rid?
Dismissed.
You said got rid. That's a form of words implying you were dealing with someone totally undesirable.
Mr. Dealey.
Mrs. Bentley, do you honestly ask the jury to believe that that letter and what it said had nothing whatever to do with your decision not to confirm Miss Lord's appointment? It's very difficult to see how you could possibly have kept it out of your deliberations. Especially since you frankly admitted here that my hypothetical case presented you with a difficult question.
Well, the fact of the matter is that the letter may have assured me, for quite different reasons, that I was right to decide not to persevere with Miss Lord. But my decision was taken on the grounds I have already stated, and on no others.
Thank you, Mrs. Bentley. No further questions.
That concludes the case for the prosecution, Your Honour.
Thank you, Mr. Lotterby. You may stand down, Mr. Bentley.
Sure.
Your Honour, before calling my evidence for the defence proper, I should like to recall one of the prosecution witnesses.
Oh, who would that be, Mr. Dealey?
Constable William Forbush, Your Honour.
Yes, of course, if you so wish. But in view of the time, I will take that in the morning, Mr. Dealey.
Court will rise.